Hi, Tim Blankenship here with Divorce661.com, and this is just a quick video. I want to talk to you about whether or not you need to notarize your divorce judgment paperwork and you need to turn it in. So I'm just, as a blanket statement, I'm going to tell you yes. What I've done as a practice, probably in the last year, is just advised all my clients, regardless of the circumstances rather, is just across the board, both the parties, petitioner and respondent, should always have the final signature page notarized. When we prepare a judgment, we will prepare a page that just has a signature line for the petitioner, the respondent, and the judge. We also have a notary acknowledgement at the bottom, so you can take it and have it notarized simply. The reason we're recommending that you, across the board, regardless of the circumstances, that both parties get it notarized, is we're starting to see a trend. And this started about a year and a half ago, where a clerk here and there around, throughout California is requesting it even though it wasn't normally the case. So let me give you some scenarios. If you had an uncontested divorce where the petitioner filed the petition, the respondent filed the response, and that's what you consider an uncontested case, then you didn't need to have your signature notarized, and that's because they know that both parties are involved. The reason the notary there is, of course, to make sure that it's actually the signature of the parties. And when no response is filed, in a case of a default or a hybrid, where we have a default with the agreement, that again is a time when you would need to have your signature notarized, the respondent. Then what started happening is on long-term marriages where we are terminating spouse support. So I don't want to get too much into the weeds on this, but in a long-term marriage, the general rule is that California law states that there is reserved jurisdiction over the issue of spouse support indefinitely. However, many clients want to terminate that jurisdiction, so there's waiver language to do so. So then what happened, because spouses were giving up their rights to spouse support on long-term marriage and wanted to waive it, the courts wanted to verify, and by doing so, asking that even on uncontested cases, that the parties have their signatures notarized. So it's just easier across the board to tell our clients, everyone get your signature notarized, both the petitioner and respondent, on every case, whether it be default, hybrid, or a uncontested case. Tim Blankenship, Divorce661.com. Hope this video was helpful. Call me if you need any help with your divorce anywhere in California. You can schedule a consultation with me right off our website. You can go to Divorce661.com. Look for the blue button, says schedule a call with Tim, and you'll have access to my calendar and we'll get you set up. Talk to you on the phone and see if we can help you out. 661-281-0266 and also at Divorce661.com. Thanks so much for watching. Take care.